So my next question is, what does a fair process look like? How can I ensure if I'm facing redundancy that I've been fairly treated?
I mean, there are two ways. I mean, it depends how big your employer is. And so I'm going to take you through some of the requirements that are in the Trade Union Labour Relations Consolidation Act 1992. And that sets out what a consultation process should look like if you're dealing with more than 20 people. Now, if you're who are at risk, so not an employer of more than 20 people, but where more than 20 people are at risk of redundancy. In all other circumstances where it's less than 20 people, we would generally consider that what's in that legislation is good practice, and not following that process, whilst not unlawful in itself, would point towards the process being unfair. But obviously, whether or not the process is fair depends on your employer, precisely what they do. You know, if the employer decides that they're not going to have any more employment law experts, then there's not really much you can do to avoid. It doesn't matter what the process is. If you're the only employment law expert, that's it. But I'm going to take you through the Trade Union Act anyway. First, there's a requirement to consult with representatives. Normally, we would expect those to be trade union reps, but a lot of places don't have recognised trade unions where they work. So what happens there, and again, I've survived 3 redundancy processes and volunteered for the 4th. And what happens is you just elect from amongst yourselves. You just nominate people to be your representatives. And they will then be the people that your employer goes to and brings proposals to and has most of the discussions with, and then that's fed back to you as a larger group of employees. This sounds obvious, but the consultation has to be genuine. So it shouldn't be predetermined who should go or how many people should go, and it should be inclusive. So there's no point allowing your employees to elect a representative or a group of representatives and then the next day making the decision about what you're going to do and how you're going to do it. There has to be enough time for those representatives to actually be involved in the process. So the best way to ensure, I suppose, that the process is fair, if you have strong opinions on it, is to get elected as one of those representatives. But yeah, those representatives should be listened to, they should be properly involved. And that obviously doesn't mean that the employer has to do what the representatives want, but just that they're keeping an open mind and involving them in the process. If there's more than 20 employees, there are statutory minimum periods of consultation. So if there are more than 100 people at risk, it's 45 days. And if there's more than 20 but less than 100 people at risk, it's 30 days. And again, we would say that good practice, if you've got less than 20 employees, is to consult for 30 days. Again, if the employer's not doing that, even if they're not legally required to do it, it is going to point towards dismissal possibly being unfair if and when it comes. So the Act says that the employer has to provide certain types of information. So the reasons for its proposed business change or the proposed redundancies, numbers and descriptions of the proposed employees. So, 20 admin assistants, 3 secretaries, that sort of thing. Total number of those types of employees at the company, so that you can see how big a proportion are being got rid of. Proposed methods of selection, and that is obviously really important because that is where most of the disputes come from. And proposed methods of working out your redundancy payment, so that you can see at an early stage whether or not your employer is using the right calculations, the calculations we talked about. Like I said, methods of selection is the big one. One of the most common complaints that we get is that people don't know how they're going to be judged when competing against their colleagues. When you have 10 people being knocked down to 7 people all doing the same job. And it's important that they actually give this information directly to you. It's not enough, and there is a case on this, I forget the name of it. It's not enough to just put things vaguely out in the public domain that you could have found if you were paying attention. They have to give that information directly to you, whether it be by an email or in a letter or in a meeting. You're not expected to go all Scooby-Doo and figure it out for yourself. And if the law does apply to you, so if you are in a group of people at risk of 20 to 100 or more people, then there are claims essentially for that on its own. So even if dismissal ends up being legally fair, or you avoid redundancy, there are still what we call a protective award, which I'm not going to go into a lot because it's very complicated. So there is, if you feel that the process isn't being done by those statutory minimum requirements and you're in a group of at risk of more than 20 people, then go get advice really quickly, because you potentially could bring a claim that could bring a claim about that on its own. And the other thing I'd say about fair process, and I think there's probably a question on this, is about suitable alternative employment. Because that's the best way to avoid redundancy for you personally. If there's another job in the company that you can do, what we call suitable alternative employment, you might hear people say suitable alternative vacancy, but there doesn't actually have to be a vacancy. It could be someone else's job that you could do better than them. And that's called bumping, where you get offered this person's job who's not at risk. And they get dismissed for redundancy. They'll still get their redundancy payment even though they weren't at risk. We might talk about that a bit more. I don't know if there's going to be
that sounds very interesting.
Well, I wouldn't go that far, but it's one of the things that people don't think about. But yeah, so suitable alternatives. I think it's probably helpful if I kind of go through this a bit, Jasmine, because it's the most common way to get out of the redundancy.
Yes.
Basically, if there's a suitable alternative role which should be offered to you, now that sounds really simple. I mean, you can ask your employer for whatever job is going, and if they want to give it to you, if for example you were the head of accounts and one of the receptionists decided to resign, and you were willing to go down to being a receptionist, and the employer was up for it, then you could do that. But they're not obligated to offer you that. They're only obligated to offer a suitable alternative. And similarly, if there is a suitable alternative and you refuse that alternative unreasonably, that's one of the few ways in which you can actually be denied a redundancy payment. So it's important to know at both ends what a suitable alternative looks like.
Sure.
So the obligation is on your employer to look for suitable alternatives and to keep looking until your dismissal happens. So in theory, even when you've been put on notice of redundancy, your employer should still be looking, a notice of dismissal, I should say. The employer should still be looking to see if there are alternatives that they could offer to you. Now, as anyone who's heard me advise about reasonable adjustments in disability will have heard me say the same thing. It doesn't matter if the employer's got the obligation. In practice, you need to be proactive. If you know that there are roles in the organisation that you could do, that you'd be willing to do, you need to be bringing them to their attention. It doesn't absolve them of their responsibility, but it's just practically good sense.
Sure.
So like I said, it will usually be a vacancy, but it can include a job occupied by someone else. That's called bumping. So if you hear someone talking about bumping, that's what they're talking about. So the example I always give is, let's say you have 5 secretaries and 1 receptionist, and your employer decides they want to get rid of one of they only need 4 secretaries, but the receptionist that they have is absolutely useless, but you as the 5th secretary would make a great receptionist. In principle, the employer is entitled to decide that you're the better person to do that job and dismiss the receptionist and move you over, and that's basically what bumping is. And the good thing for the receptionist is that even though the receptionist wasn't actually at risk of redundancy, like their role was not being made redundant, they will still be dismissed for reason of redundancy, and so they'll still get their payment. So you don't have to feel too guilty if that happens. So what is and isn't suitable? First of all, it's an objective test. So that means that a tribunal will look at it, not necessarily looking at all of the specific circumstances. So the two roles have to be similar enough to each other. So if you're working at Heathrow as a security guard and you hear one of the air traffic controllers is leaving, that's probably not going to be a suitable alternative, because the role is so different to the role you're doing, and there's a level of training involved, and you might crash a plane. So that's not going to be a suitable alternative, obviously. It is kind of important not to get bogged down in job titles. It's what the role actually is. It has to be similar enough in terms of skills and experience needed. But like I said, a security guard's not going to have all of the skills required to be an air traffic controller, but a checkout operator at a supermarket will probably have the same skills and experience needed to work in the kiosk, selling lottery tickets and cigarettes. So if you were at a supermarket and they decided to reduce the number of checkout staff, but they needed more kiosk staff, then that would be a suitable alternative, I think. And functions and status are also a factor. So if you're the manager of a workplace, going down to assistant manager, most of the skills are the same. So you could do the job, but the skills and the status, sorry, not the skills, the status is definitely lower. So it probably wouldn't be suitable because it's a downgrade in your status. Now I'm just going to run through a couple of quick examples, which I think are more helpful than me just talking. So a wirer offered the job of an assembly operator. It was a less skilled job, so not suitable. A senior manager who'd worked behind a desk for 35 years offered a lower grade job involving manual work, was not suitable. A job where the standard paid the same, but there was no commission, which the original job had, that's probably not suitable. And again, these are employment tribunal findings. So when I say probably, it's, the tribunal was not quite sure about it. Going from night work to day work, so this is something that I've done. So I did night work for 10 years, and I can tell you it's a totally different type of job, working at night, from even working sort of 5 a.m. to midday. So that's likely not to be suitable if you're switching, even if it's essentially the same job, just done at different hours. Moving from Glasgow to Newcastle, that was deemed to be suitable. But then you're looking at whether or not it's reasonable for you to refuse, and we'll talk about that in a minute. Most employers, are pretty difficult to convince about moving locations, in my experience, where there's a big distance. So the employer might put up a fight that actually is a suitable alternative because it's in a totally different location. And really, it would depend on what the job was. I mean, you could argue if you were working in somewhere where the location was relevant to how the role was carried out. So, for example, when I worked in a city pub, it was perfectly acceptable to be rude to the customers because the city workers like that. They like that kind of style. But you wouldn't do that if you were working in a pub in South Kensington, for example. So it might be relevant. It may or may not be suitable for this location change. And then headmaster offered a role as a normal teacher with the same pay. The tribunal in that case found that to be so unsuitable that they called it most unsuitable, which is may not sound like really strong language, but it really is pretty strong language from a judge. And they compared that from being the ship's captain to going to being a deckhand, so not suitable. Now, if they offer you an alternative that is not suitable, but you want it, then by all means take it, because that's never going to go before a tribunal. No one's ever going to dispute that. And vice versa, if you can convince them to offer you an unsuitable alternative, that's great. But the problem is, if that happens in either scenario, that would probably disadvantage someone else. And if they are suitable for the vacancy, then it's a big risk for the employer to go for someone unsuitable, because then there's a risk of an unfair dismissal claim from that other person.
Sure.
So normally employers will play it safe. And if you are offered a suitable alternative and you take it, there should be a 4-week minimum trial period. Now, that at the end of that trial period, you can say, no thanks, don't fancy it, it's not for me, and you get your redundancy payment more or less, no questions asked. But it is 4 calendar weeks. So to use, again, my scenario as an example, when I switched from day work to night work and back again, I only worked every other week. But my trial period was still 4 weeks, even though that was just 2 working weeks, because that's all you're entitled to. It's the same, if you only work 1 day a week, it will still be 4 weeks. It won't be 28 working days or 20 working days. So it can be extended by agreement, but you just can't force. So in either of those circumstances where you're offered a suitable alternative or you take it as a trial and then you decide not for you, you can only get redundancy payment then where it's reasonable for you to reject. And there's going to be some overlap between whether a job is not suitable or where it's reasonable to reject. And in fact, I think we've all been guilty actually of kind of conflating the two when we advise about what's a suitable vacancy. But the Glasgow-Newcastle option is a perfect example of that. So it might be a suitable alternative role. So it might be exactly the same job, but it's reasonable to turn it down on the basis you've got kids in school who don't want to move schools, or you don't want to live in Glasgow because you really like Newcastle for some reason. The further the move, so the further away the new workplace, the more likely the refusal is to be reasonable. And the same goes for commuting. If you're asked to go from working round the corner from your house, which I'm lucky enough to do, to working somewhere that's on the other side of the city or in a different town or a different city, again, the vacancy may well, or the employment might well be suitable, but it's not suitable for you, so it's reasonable to refuse it. Change of hours are the same. So again, I don't have children, but I try and always think as if I do, because that's normally a lot of cases about reasonable refusal are, well, my kids come out of school at 3:30, so I need to be out of work at 3:30. So if you change my hours, then it's reasonable for me to refuse it, because then I can't pick up my kids for school. I have to get someone else to pick my kids to school. So that's likely to be reasonable. Time off is another one. So if there was a case, again, I'm not going to give you names of cases because that's boring. But when there was a case of a labourer who worked a 4-day week, and he was offered the exact same job essentially on a different site round the corner, but it had to be a 5-day week. And the labourer said, no, thank you. My time off is more valuable to me than the extra. And they offered him more money, obviously, to work the extra day. And he said, no, thanks. My time is more valuable to me. And that was deemed to be a reasonable reason to refuse. Okay. And, I've worked 7 days on, 7 days off for 10 years. And I really valued that extra time. So I don't think anyone's going to dispute that having more time off is reasonable reason to turn down a new job. And demotions or change in status are the more tricky ones.
Yeah.
So, for example, there was a case of a butcher's shop manager who I presume, I can't remember the precise circumstances, but I presume their shop was taken over by a larger company. And effectively, he was offered the alternative of manager of a butcher's department in that larger company. And the tribunal found, to my recollection, both that it wasn't a suitable alternative because the status was different, but also that it was reasonable for him to turn it down for essentially for exactly the same reason, that it was okay. Your pride can be a good reason to turn down a job in some circumstances.
Okay.
And specifically, there was a case where a manager was being moved into just kind of the ranks, as it were. But in those circumstances, it was a reasonable alternative. But his new manager was someone that had worked under him before and who he didn't have a good relationship. So it was therefore reasonable for him to refuse. So the short version basically is it will depend. But those examples kind of give you an idea of where a vacancy is likely to be suitable, and even if it is suitable, where it's likely that you can reasonably refuse it. Okay. And if there's a dispute there about either the suitability or the reasonableness of the refusal, then, and you don't get your redundancy payment because the employer says, well, you're not entitled to it because you unreasonably refuse a suitable alternative, then you can bring a claim just about the redundancy pay.
Okay.
And unlike most other claims, you actually have 6 months to do that. Most other claims are 3 months.
Sure.
And so you could say, look, the dismissal was perfectly fair. I have no problems with the dismissal. I don't want to bring an unfair dismissal case, but you can just bring a case for redundancy payment.
Great. Thanks, Dave.
Yeah.